All right. My name is James Greenwood. I'm thrilled to conclude our IP at Lunch webinar series with today's topic, which is actually mildly interesting. Um, this is why IP matters, and this is really for our SMBs and startups. This is it's a hot topic. It's something that we get asked about a lot. Do I need to have the rights or do I need to own IP? Why is this important? And we've hit on this throughout the webinar series. Um, Before we go any further, my name is James Greenwood. With me today, I have Phil Schaefer. He is our IP of counsel here at Greenwood Law. Today, we're going to be talking about a number of topics, but it's important to remember that we are not your attorneys. And just attending this webinar or watching it online later on or listening to the podcast doesn't make us your attorneys. Instead, you must speak to an attorney and actually obtain representation for this. Additionally, just a reminder, look, this is for educational purposes. Okay, guys, this is not intended to be legal advice at all. You're going to want to talk to an attorney who knows the specifics of your case, who's going to be able to provide you clear, well-founded legal advice. You don't want to rely on some podcast or some online webinar. As much as we think of these things, the reality is that when we're providing tailored legal advice to a specific situation, it may actually differ from what we're presenting here a little bit. I mean, this provides some education, but it's not the end all be all. So that's the other thing to kind of keep in mind here. All right. So with all that said, Phil, thanks for joining me today. Big picture, again, let's start with the basics. What the heck is IP at all in the first place? In case somebody missed everything else and they're just joining us, what is IP?
IP, well, let's start with what it stands for. It's intellectual property. So it's a type of property that you own. It's a means for yourself or an entity to make money. It's something of value. So I guess that being said, it's either a copyright. I mean, the broad four are patents, trademarks, copyrights, or trade secrets. And there's other I guess iterations of that, but that's typically what we're referring to generally.
Absolutely. And I think the thing that you've hammered on and that I've hammered on is really the thing about IP is it's something that gives you a competitive advantage. And that's the reason why you would establish a trademark or create a copyright or create copyrighted material or get a patent or want to keep something secret. Fundamentally, it's something that you're making money with. And I think that cannot be emphasized enough, right? Generally, this is why we care about IP at its core. It's about being able to do business and protect your business. And so let's talk about, let's start with trademarks because, again, I think that we have this kind of idea in our heads that, oh, IP is this esoteric thing, but really, and when we're planning and we're looking ahead and we're building a business, hopefully, when people watch this, they're watching it because they want to get ahead of things and they want to build a business that's something that they can rely on for a long time, right? And they're like, okay, we're going to plan ahead. When they go to do the IP portion of that business plan, trademarks are the things that really stand out. That's the thing that everybody kind of, I think, sees. It tends to be the public facing piece of this, right? So talk to me a little bit about trademarks, just briefly.
Sure. Now, as it relates to
Brand names, business
or
names,
plan?
logos, brand identity, and how do you protect that? Just broad strokes, big picture.
Yeah. Okay. So one is I mean, yeah, trademarks is typically what you're holding out is the first thing your customers will see, whether you're providing a service or a product. It certainly can be your logo, but it could be a slogan that you're using. It could be um, in some cases a scent or a color. It's whatever is differentiating your product or service from other competitors on the market. So one of the first steps to take with that, although it's not required, is registration. So you can register a trademark with the USPTO, and what that gives is a number of benefits, but I think the biggest one is the presumption of validity across 50 states, whether or not you're selling in every geographic region within the US or not. So it gives a broad level of protection just by registering. The act of registering gives a broad level of protection. And then as a business, you do have to be careful of the use in allowing others to use things similar to your trademark or appropriating your trademark outright, because trademarks is one of those things that if you allow others to use over time, it can dilute, and then you no longer have the same level of protection that you once did. So a zipper at one time was a trademark. Now everyone just calls a zipper, no matter what it is or who makes it. And it's become a common noun. And so that's one example of how it can dilute over time, where it's no longer identifying just your product or service.
Yeah, absolutely. And so, actually I remember this was a big fight back in the early 2000s where Google went really out of their way to say, you're not Googling it, you're doing a web search.
Yeah,
Because it became ubiquitous. Oh, I'll just Google it, right? And that was a big thing that they pushed. Hey, you're not Googling it, you're just going to do a web search.
Yep. Or if you're going to Xerox something, same principle.
Exactly. Yeah. Okay. So let's move on to copyrights. And big picture. When they're doing, and these, then I guess when we're doing a plan, I think the takeaway here is have a plan for what your trademarks are going to be. Identify those things, right? And then decide whether or not make a positive decision about whether or not you're going to register those trademarks. And that needs to be part of the plan. It's something that a good business attorney should be able to sit down and talk you through. Okay. Copyrights. Let's talk about copyrights. As people are planning, they're kind of looking ahead. They're saying, hey, we're getting ready to go into business. Why do we care about copyrights? What needs to be copyrighted, or what do we need to throw in the business plan about copyrights? Well, Phil,
Yeah.
What is this copyright thing, and what might need to go into that business plan?
Yeah. So again, a copyright is an artistic expression put in a fixed medium. So artistic could be a full range of things. A business report could very well be that expression. And then as long as it's in a fixed medium, such as a website, a written form, or a digital file, most businesses, whether they put a plan around it or not, have some form of copyrightable material. What essentially what it protects is the expression of the idea, but not the idea itself. So if you have a website layout that is it differentiates you from other competitors, and it's worth protecting, then that would be something to consider registering with the Copyright Office. And again, similar to trademarks, registration is a key component here. It could easily be done through the U.S. the U.S. Copyright Office website, as could trademarks for the USPTO. However, you have that right, excuse me, not you, but the creator has that right just merely through the act of making that artistic expression. So it's not something that needs registration in order for you to have a right. It's just that registration confers additional benefits and then creates presumptions, and then also allows others to find out who owns it. So there's another range of benefits there, but it again doesn't just necessarily create a copyrightable interest just by registering. That is done by simply creating the work.
Okay, perfect. And then as far as really what needs to go into that business plan, I want to emphasize this.
Yeah.
You need to identify, hey, what's copyrightable here? What are we creating? And this could be, maybe you are a website development house. Who owns the copyrights? Are you just doing work for hire agreements? Are you creating the websites and licensing those websites, those copyrighted websites? Are you just licensing the copyright to your customers, or do they own the website outright? Who has the right to the materials that you're drafting? If you're doing blog posts for people, do those need to be protected? Should those be protected with contracts? Do you own the copyright, or does the end customer own that copyright? So all of these things need to be kind of thought through at the very least. And some of the defining the value of what you're providing and how you're providing that value and how people are paying you for that value needs to go into that business plan. All right, patents. I feel like this may be a little obvious for, this tends to be the core of what if you're starting a business and you got a patent involved, I feel like that would be like the core of the business itself, right? But maybe I'm wrong. Phil, I mean, what's your take on that?
Oh, I think you're right. When we're comparing it against others, the other forms of IP with a copyright or trademark, oftentimes those are incidental to the activity being performed. Again, your business might not be just your website, but your website is your copyrighted asset. Typically, you're right. The patent it's the product. It's the thing that you're selling. It is the method of production for whatever you're making. So there is I guess a stronger line for a patent to the to valuation than there might be for copyrights or trademarks, at least in my opinion. Let's see, so I guess that makes business planning a little more straightforward in a way. And it's a lot easier to list out. A patent is one of those things, either you have it or you don't, or you're in the process of pursuing it. I guess one thing to keep, oftentimes where you might be business planning is when you're in the process of determining if you can pursue patent protection, where you might be looking at because it's a bit more expensive to obtain patent protection than the other forms of IP. That's certainly something that you want to evaluate up front is this innovation that I've undertaken, is this worth, or am I able to patent this? And then obviously there'd be planning in terms of how to and how to budget for that, and what exactly to seek protection on would probably be the more upfront consideration than anything else. If you don't already have patent protection on whatever your business activity is. Does that make sense, James? Or I don't know.
Yeah, no, absolutely. And I think that's probably what needs to go into that business analysis, right? Is what are we doing with this thing? Have we filed our patents? Do we need to file them before we go into business? And when you're doing that inside of that business planning context, it also needs to be how do we monetize this conversation? Absolutely. So I think I think you're on to, I think you got it. And I think, when we're talking about this with our clients, our clients are in this for the money, right? They're not doing this
Yeah.
different stuff for nothing.
And conversely too, and this would hold true obviously for copyrights and trademarks as well, as if you're if we flip that on its head and you aren't the person that created the thing and that you don't have the patent, then part of your business planning will involve, okay, is this something, what would it cost for me to just buy the rights to this patent, either through completely and be the assigned owner of a patent? Obviously, there's a dollar amount to that oftentimes, or then licensing. How can I go about pursuing licensing in a um, fiscally responsible way? And that you get into the scope of the license, like we talked about in previous discussions, where there really wouldn't be a whole lot of point in getting a broad range of licensing rights and paying more money for that than what you're intending to use. So that is definitely part of the planning phase as well, if you're not the owner of the patent rights.
Absolutely. So, all right. So when we start talking about all these things, right? We're talking about, um, patents and copyrights and trademarks. There's kind of one last category that you talked about briefly, and that's our trade secret category. I think one of the things that people underestimate is the value of a trade secret until it gets lost, right?
Yeah. Yep.
So what's the implication of a trade secret as you're planning for business, as you're thinking about, hey, how do I do all of this and make a plan on this business? Does that make sense? So
Yeah. Yeah. So the implication is keep your mouth zipped, I guess. Like and just I said, I'm intentionally saying that crassly, but with a trade secret, if you have a competitive advantage that you don't want others to know about, the worst thing you could do would be to disclose any information or make public otherwise that which gives you the competitive edge. And so you yourself as a business owner, a business administrator, but also to any agents of the business, contractors, employees, you want to make sure that you keep that trade secret locked up tight, so that you don't lose your right to exclude others from having that information. And same thing with a patent too. If you haven't filed yet, you certainly you have to worry about public disclosure when you're working with something that could potentially have uh, you could pursue a patent with. There's timelines to all that with a patent, but I mean, generally, you really want to be careful at the outset, before you start doing anything, to know who you're going to disclose information to, under what circumstances, and making sure that you're taking reasonable efforts to protect whatever needs to be protected. And that's where your internal policies and your access policies, uh, everything comes into play there.
all right, great. And then so I was asking all of these questions in the context of somebody starting up, right? And
Yeah.
so
Yep.
when we have these trade secrets, and I'll just continue down that track for just a second. When we have these trade secrets and everything like that, it's important to identify what exactly differentiates, what's the unique differentiator for your business. And a good indicator that you've got something that might be a trade secret is it's not clearly visible from a public perspective. It may provide an edge in the marketplace. And so it could be, something as simple as your recipe book in a restaurant context. It could be, something as complicated as an advanced series of equations that help you predict market algorithmically predict market fluctuations.
Mhm.
But the key is it's something that may not be visible and may be sitting in the background. I've seen trade secrets sitting in Excel spreadsheets before. I mean, it's wild.
Sure. Yeah.
So my take on this is, if you're going to be starting a business and you're writing that business plan, identify what it is, what's your unique selling proposition, and what drives that. And if there's something that maybe isn't visible to the customer, to that end customer or end client, depending on your industry, that's something that might be a trade secret, and you might want to exercise some discretion on protecting that. So worth a conversation with the attorney to kind of help you ferret out, what exactly that is. Now, let's talk about what happens if you've got a business and you're like, hey, I don't have any, I just got a bunch of employees. They started, maybe you got a bunch of 1099 folks running around your business. They're doing a bunch of stuff. And you look at it and you realize you've got some kind of unique advantages in the market, but you never got any like written contracts out there. You don't. It's all just verbal, And a lot of people start their businesses and they just start up and they're just out doing their thing for a long period of time. Maybe they started an LLC on the Secretary of State's website. What can that person do, or that small business do, to kind of say, hey, I need to maybe reel some of this back in and maybe make
Yeah.
my relationships a little more clear? What's kind of that first step there for them, Phil?
Well, okay. I'll give you my answer. You might differ, so I don't know if there's a right one, but the first place I would look is obviously after you've identified that which you want to keep either secret or protected or confidential. The first place I would go to would be internal policies and procedures, making sure that you have pretty clearly delineated all the ways and means of which you would keep that secret, and then have as a condition of employment, those associates or employees acknowledge that with some sort of affirmative acknowledgement that yes, as a condition of employment, I agree to abide by these policies and procedures, to keep XYZ confidential, and only disclose under XYZ circumstances.
Okay. Yeah, and I think you kind of you mentioned it, but identifying what you have, right? So that's an IP audit, right? That's the kind of the very first step, and it's actually probably the most labor intensive step, and the step where an attorney can really provide an enormous amount of value being in the mix from the jump.
Yeah.
It's going to take some time, and that's one of the things, and it tends to be a little expensive to do, both in time and money. But if you've got something that really differentiates your business and makes your business go much more effectively than your competitors, that's a great moment to kind of define what that is and identify how you can stop your competitors from coming in behind you and just copying everything you've done, right? And this becomes especially important, I think, in the world. I've seen a number of businesses where they've got a lot of folks operating just as 1099 kind of folks. They're independent contractors. And any one of those independent contractors can just come in, and theoretically, if they've got enough knowledge, they could come in and just scoop that business. There's nothing
Hmm.
that stops them, especially
Right.
just
Yeah.
on verbal agreement. So having those defined relationships up front can prevent some of that. But if that already exists, then basically what you can do is you can say, hey, we're going to modify these contracts depending on the relationship and what the totality of the agreement is. And you can come in, do some contract modification. The employees, in a lot of ways are a little interesting. Those modifications that you talked about, usually we actually suggest doing a um, uh, an additional bonus around bonus time. So you got the baseline bonus that's part of the comp plan, but maybe do a small additional bonus and have that tied back to those modification of employment conditions. And that's just to make sure that we have adequate consideration. It's especially true in Illinois. You know, a lot of times your contracts, you know, continued employment many times isn't enough to get over the threshold for adequate consideration. So it's certainly something to kind of keep in mind. And these modifications of employment agreements can actually be quite complex. So that's one place where we've been able to really kind of help people in the past, and somewhere that I think that is going to continue to be an interesting area to operate in, especially here in Illinois, where you can't use non-competes for folks making less than $75,000, and maybe not so much in Chicago, but certainly downstate, where you know the levels of income tend to be a little different than our Chicago market. So when we have those things, you know, that's certainly something, you know, it's important to think about budgeting. You know, how much do you budget for this? And it's going to vary from industry to industry, from company to company. Some companies that are driven by their trade secrets and their copyrights and their trademarks. You know, it's quite valuable. I mean, same goes for the IP, the guys who are driven by their IP. Thankfully, most of our IP folks tend to be pretty well documented. They tend to be pretty good about at least getting, or their patent folks tend to be pretty well documented and tend to have their stuff submitted to the USPTO. So usually that they're not the problem. The issue is really around that copyright and trademark work and the trade secrets work. So that's where most of, I think, the soft IP side of it, I think, is where most of the work actually tends to live on these folks who've been in business a minute. So anyway, Phil, thank you so much for joining me today. Any last words, parting words here as we wind up our IP at Lunch series? Last thoughts, kind of things that people need to keep in mind.
Well, I want to thank you, James, for inviting me onto the series and having allowing me to participate in it. It's been fun. I guess the last parting bit I would offer to our audience is that oftentimes we have like a typical business operator or owner will not really consider what they're sitting on, and it's oftentimes, more often than not, what I've seen is it's actually more than what you realize. So bear that in mind, and there's ways to make that work for you, and also to increase your bottom line. So please, you know, carry that forward into your day-to-day work. And if there's ever any questions about what you have, what you want to do with it, please consult an attorney that is trained and has expertise in the area so that you can make the right decision for yourself.
Perfect. All right. Well, thank you so much for taking the time out. I really appreciate it. If you my name is James Greenwood. With me, I have Phil Schaefer. I am licensed in Iowa and Illinois. Phil is licensed to practice in Illinois and before the USPTO as a patent attorney. So as a reminder, these presentations are for educational purposes only. You should not rely on these as legal advice. If you have questions or comments about today's presentation or any of our presentations, we can be reached at 855-528-6022. Thank you so much for joining us over the last 10 weeks, or 12 weeks, actually. We kind of extended this. And we look forward to seeing you all in the future. Have a great day. Goodbye.
Thank you.